Good morning, everyone, and thank you for joining us today. My name is Allison Lee, and I'm here with my colleagues Ethan Sachs and Gemma Lewis for today's webinar. We have roughly 2,500 people who registered for today's webinar, which reinforces the importance of today's topic: workplace accommodation, mental health, and substance use disorders. The format for this morning is as follows. We'll present from 9 a.m. to approximately 10 or 10:10 a.m. and then answer questions until about 10:30 a.m. If you have a question for us, please type it into the Q&A box on your screen, not in the chat box, which should be disabled. We'll do our best to answer as many questions as we can. If we don't get to your question, please reach out to us after the presentation. Finally, a recording of today's presentation and the slide deck will be on the homepage of our website in a day or so. With that, let's get started. So today's topic, as I said, is workplace accommodation, mental health, and substance use disorders, and we'll be dividing into three main topics. First, my colleague Gemma is going to talk about workplace accommodation frameworks. Then I'm going to talk about mental health accommodation. And lastly, my colleague Ethan is going to talk about substance use disorder and accommodation. With that, I'll turn it over to my colleague Gemma.
Good morning, everyone. Thanks so much for coming to the workshop today. And thank you very much to my colleague Allison for that warm introduction. As Allison said, today we're going to be talking about the workplace accommodation framework first. And we like to use a framework because we know that accommodation requests can be quite complicated. And because of that, a framework allows us to have a clear roadmap of how to respond so we can make sure we're doing it in a fair, consistent, and effective way. Now, throughout the presentation, we're going to be referring to Ontario case law, but it's important to know that the general workplace accommodation framework is quite similar across all provinces. As a background to discussing the employer's duty to accommodate within the workplace accommodation framework, it's useful to first consider what is considered discrimination. And this is just a roadmap. We're going to get into it a little bit more throughout the presentation, but to prove that there's a discrimination on the basis of a disability, the employee has to prove three things. First, they have to prove that they have a disability. Second, they have to prove that they suffered an adverse treatment. And third, they have to show that the disability was a factor in the adverse treatment. And we say a factor because if the disability even played a small role in the adverse treatment, that's going to be enough to prove discrimination. Now, if the employee is able to prove these three things, the burden then will shift to the employer, and they have to show that to prove discrimination, they have to, the employer must accommodate the disability if the employee shows discrimination, unless the accommodation is not feasible. So to show that the accommodation isn't feasible, an employer has to show two things. First, that there's a bona fide occupational requirement of the role that the employee can't fulfill, and that's just a standard or requirement that's necessary to perform the essential duties of the job. And second, they have to show that accommodating the employee would cause something called undue hardship. And again, we'll get into that a little bit more later in the presentation. As we saw previously, before an employee can claim discrimination, they have to first show that they have a disability. And if they don't have a disability, then an employer does not have the duty to accommodate. So because of this, the definition of disability is a really key issue in the workplace accommodation framework. So what is a disability? It includes things that are mental or physical. It can be temporary, permanent, acquired, or developmental. So for example, some mental health conditions such as PTSD can be episodic, only coming up at certain times in the employee's life. And a disability can also be perceived. What this means is that even if someone doesn't actually have a disability, if they're treated unfairly because the employer believes that they have a disability, that can still count as discrimination. So even though it's a very broad definition, and you can see that from this slide, there are certain things that disability does not encompass. And these are things like personal characteristics. So for example, being a messy person or being a shy person. It doesn't include things like common or temporary ailments, so common cold. And it also doesn't include ordinary stressors in the workplace. For example, stress due to a performance review that's coming up or a looming deadline. As an example of a definition of disability, we have on the screen here the definition from the Ontario Human Rights Code. And in the Human Rights Code, disability is defined as any degree of physical disability caused by injury, birth defect, illness, including brain injury, paralysis, amputation, speech impediment, epilepsy, reliance on a wheelchair, and some others. It also includes a condition of mental impairment or developmental disability, a learning disability, a mental disorder, or an injury for which benefits were claimed under workers' compensation. So the substance of the definition of disability is quite similar across Canada, although in the actual statutes, there are specific nuances between the provinces. For example, in Ontario, it specifically includes injuries for which benefits were claimed under workers' comp. Not all provinces actually have a clear definition of disability in their legislation. For example, British Columbia and Manitoba. In Quebec, the word handicap is actually used in the English version of the legislation, and some provinces might not include specific types of disabilities. So, for example, PEI doesn't specifically reference the term learning disability. But as I said, despite there's the differences in these definitions, in practice, what is considered a disability in one province is likely going to constitute a disability in another province as well. On the screen here are some statistics about disability in Canada, and I'll just go through them briefly. So 27% of Canadians age 15 plus currently have at least one disability. 10.4% of Canadians in the same group currently have a mental health related disability. And then by age 40, roughly half of Canada's population will have or have had a mental illness. And these are just some common ones: major depressive disorder, general anxiety disorder, bipolar disorder, and substance use disorder. So these stats really indicate that disability in the workplace is a lot more common than many employers might realize, which means that in most workplaces, at least one person is likely going to need an accommodation, whether it's visible or not. So it's very important for employers to understand how to respond to these accommodation requests because it really helps in meeting legal obligations. We're now going to look specifically at the employer's duty to accommodate in the workplace. One part of this duty is the duty to inquire. The duty to inquire means that if an employer notices that an employee might be struggling due to a disability, they can't just ignore it. They have to take reasonable steps to ask if accommodation is needed. Now, we want to make it very clear, though, that the duty to inquire does not arise in every single situation. It might arise if the employer notices a pattern of behavior. So, for example, increased absenteeism, changes in hygiene habits, increased mood swings, and other things like that. That might indicate that the duty to inquire has arisen. We know that this can be very awkward, right, to ask if someone has a disability. And we're not advocating for employers to just go around asking employees if they have a disability just because they came to work one day looking a bit disheveled. We're talking about a situation where the employer has a reasonable basis to believe this, right? So there has to be some sort of change in the employee's conduct that would give rise to a reasonable expectation that the conduct might be explained by some kind of disability. Now, the duty to inquire is particularly important in the context of mental health and substance use disorder. And that's because employees suffering with these types of issues might not want to disclose on their own that they're suffering. This is because they may not be aware that they even have a disability. And even if they know, they could feel that there's stigma surrounding it. So it's really important to be aware of this kind of unique situation when it comes to mental health and substance use disorder. And my colleagues Ethan and Allison are going to go into more detail specifically about these kind of situations later in the presentation. So this is a case from the Ontario Human Rights Tribunal, and it's really helpful in showing the application of an employer's duty to inquire. In this case, the employee had discovered that her coworker took inappropriate photos of her at work, as well as some other people. She had expressed that she felt upset by this incident and she actually had to go off of work. So she provided a medical note in August that she needed to be off work due to medical illness without really much more information. So clearly that didn't provide too many details to the employer. And she actually ended up not returning to work in August. In September, she had consulted with a psychiatrist, and the psychiatrist said that she would likely not be able to return to work for 3 to 6 months. So at this point, after receiving the note, the employer terminated the employee's employment because they felt that her job was really pivotal to their operations, and they couldn't afford to have her off work for such a long period of time. At that time of the termination and receiving the note, the employer was aware of the incident that happened at work to some degree, maybe not the full extent of how it affected the employee, but they had some awareness that something had happened and that she felt upset by it. Despite knowing this, the employer did not seek out further information about why the employee needed time off, and instead, as I said, terminated her employment. The HRTO found that the note from the psychiatrist had put the employer on notice that the employee might be suffering from a disability and that the employer failed to inquire by asking for more information from the employee. And because of this failure to inquire, the employer did not meet its duty to accommodate. So now we know that an employer has the duty to accommodate, and the next question becomes how much? The answer to this is the point of undue hardship, and we'll first start talking a bit more about the duty to accommodate and then get into more what undue hardship is specifically. Now, some broad principles about the duty to accommodate is that it is both procedural and substantive. The accommodation needs to be reasonable, but it doesn't need to be perfect and it doesn't need to be preferred. So, for example, we often see employees saying that they need to work from home on a full-time basis due to some sort of mental health condition. If the medical actually shows that they can be accommodated by working 3 days in office instead of fully from home, then the employer could offer that as an accommodation, and that would at least have to be discussed and likely accepted by the employee. And that's because even though they prefer to work from home full time, if they can reasonably work from home 3 days a week, then, as I said, the accommodation must be reasonable and not exactly what they want. To this end, there's a lot of creativity and flexibility in accommodation. So a lot of different options should be considered if possible. And then if these restrictions actually can't be accommodated, a leave of absence may be appropriate in some cases. So the duty to accommodate is procedural and substantive. The procedural aspect is about the process of accommodation or the journey of how we get to the accommodation. We want to be gathering information about the employee's needs. We want to be considering different accommodation possibilities. Again, creativity, flexibility, those are really important. And the reason for this is because freedom from discrimination includes having your needs considered and assessed, even if the needs can't actually be accommodated at the very end of the process. The substantive duty is about the result or the destination, so whether the accommodation actually meets the employee's needs. So the solution should probably be eliminating the barriers at the very least and allowing the employee to meaningfully participate in the workplace. If the employer is not going to be able to accommodate, they must be able to show that that accommodation would cause the employer undue hardship. So let's say we've completed the procedural process of the duty to accommodate, and we want to take the position that it would cause us undue hardship to provide it. How do we prove that? There are two different factors. The first is financial cost. So, would the accommodation threaten the viability of our organization? For example, we've had in the past clients who've provided employees with ergonomic chairs for back injuries, and purchasing a $200 ergonomic chair for most organizations is not going to threaten their financial viability. However, if the request is to renovate the whole wing of the building, then that's probably going to be a problem financially for a lot of organizations. The second factor is health and safety. So, would the accommodation create a safety risk to employees other to the employee, other employees, clients, or the public. And an example of this might be if a surgeon has a substance use disorder, allowing them to continue operating on a patient, it could create a safety risk. Not in every situation, but it definitely could in some. So that would be something that would be considered. Even though undue hardship is a very high threshold, employers are not typically required to replace another employee with the employee needing displace another employee with the employee requiring accommodation, pay an employee to perform unnecessary work. The work should be meaningful, or hire an additional person to perform the employee's duties for them. When deciding how to substantively accommodate the employee, so now we're talking about the actual solution at the end of the procedural part of the process, we like to take a bullseye approach to accommodation. And that means we want to shoot for the bullseye and we move outwards if we cannot achieve it. And when I go through these different options, I just want to note that each option can be provided with modification or without modification. So the bullseye would be keeping the employee in the same role as they had previously. For example, with the ergonomic chair, that person could probably just could just continue in their duties. They just have a chair now that will help them. If that doesn't work, then we might want to provide a comparable position. For example, if an employee is a customer service representative in a call center, but has some disability that makes it difficult for them to speak on the phone or to handle a large volume of calls due to stress, the employee can be placed in a different department where they only provide help through email or phone, or pardon me, through email or online chat. If that doesn't work, then we can think of providing an alternative position that still provides the employee with meaningful work. So, for example, an employee who's a paramedic who maybe has PTSD, and because of that, they can't work on the front line anymore and need to work in a role with training and education for new recruits. Then, if none of those work, we might want to consider a temporary medical leave of absence, an unpaid leave of absence if no role can be performed. But that would be the last option. It's not just the employer that has duties, though. So in the accommodation framework, an employee must cooperate. And that means that they have to disclose that they require accommodation and the basis for the request. They have to cooperate with the process in good faith, right? So during that procedural part, being creative and flexible. They have to be honest. They have to provide sufficient documentation to support needs. And again, they have to accept something that's reasonable as accommodation, not necessarily something that they would prefer or is their perfect solution. To encourage participation, employers may want to tell the employee that their privacy is going to be protected throughout the process, and proactively have policies that address accommodation and discrimination and the issues that they may have around privacy specifically. Now, a question we often hear from clients is, what kind of medical documentation are we entitled to ask for? And the answer to that is that employers have a right to sufficient medical information to support the assertion that the employee has a disability, requires accommodation, and to understand how to accommodate. This kind of medical may include details such as the existence of a disability, the nature of an illness, whether the disability is permanent or temporary, estimated time for improvement, specific functional restrictions and limitations. For example, Bob can lift 10 pounds but not 20, how the medical conclusion was reached, a treatment plan in some cases but not all, and an opinion as to whether the employee can perform a specific task. Now, let's say we've received a medical note from the employee and it doesn't have any of the items that I just went through, and it's unclear or deficient. What do we do in this situation? So it's important to note that employers are not required to accept deficient or unclear medical information. They can absolutely request further information through the employee or with the employee's consent through the doctor. These requests should be in writing, though, with specific questions, and also explaining what's wrong with the medical that was just received. The request may also outline demands of the job or specific areas of concern. So we will often actually send a copy of the worker's job description and duties to the doctor. So they see exactly what the employee is doing and they're able to give their opinion on specific parts of their duties. So the letter to the doctor, though, needs to be worded very carefully. We don't want to ask for more information than is required to address accommodation. We want to make sure that the employee's privacy is protected at all time. And if we still aren't receiving proper medical information, it is possible to ask for a independent medical examination or third-party review, but that wouldn't be our first move in most cases. Now, this is an arbitration case that is helpful in showing the application of an employee's duty to cooperate. In this case, the employee went on a leave of absence and they wanted to return to work with a 3-day work week, and they claimed this accommodation was medically supported. However, they didn't provide any medical information that would support what they were saying. There was a lot of back and forth between the parties, and ultimately, the employee refused to provide the medical information and actually refused to give consent for the physician to provide the medical information on behalf of the employee. The employee was warned that failure to provide the information would result in termination, and ultimately, they were dismissed. The union grieved the dismissal, and it went to arbitration. And at arbitration, the arbitrator upheld the termination because the griever failed to cooperate. The arbitrator found it was on the employee to share information about the disability, the medical restrictions and limitations. And because they refused to do so, the griever did not cooperate. And the employer, on the other hand, fulfilled their duty to accommodate and duty to inquire because it had made multiple attempts to try to get this medical information and start the accommodation process. Many of you in unionized workplaces will know there are special considerations and challenges from being in a unionized environment. We're not going to get too much into it, but it's suffice it to say that unions do have a duty to cooperate in the accommodation process as well. This includes exploring options and facilitating communications between the employer and employee. And the ultimate goal of all parties should be to work together and enable the employee to return to work safely and effectively. Unions may also need to accept modification of other employees' rights under the collective bargaining agreement in order to accommodate the employee. So a common example would be some flexibility in a shift scheduling system that's based on seniority to allow for accommodations for the employee with the disability. Now, with that, I'm going to turn it over to my colleague, Allison, who's going to talk a little bit about mental health and accommodation.
Thanks, Gemma, and good morning again, everyone. So Gemma's now taking you through the framework of accommodation. Let's talk specifically now about mental health and accommodation. So the first question we have to ask with a mental health issue is there even a disability? Remember, disability is a protected ground under the Human Rights Code or the human rights legislation in your area. If it's not a disability, it might not be a protected ground. Crowley and LCBO's a great example of this. It's a case where there was a question of whether or not there was a disability as protected under the code. In this case, Crowley, who is an employee at the LCBO, was harassed by a customer. She requests a permanent transfer to another store. She self-reports that she's experienced stress and health problems, and she provides a doctor's note to the LCBO. But what's critical here is the doctor's note does say that she should relocate, but does not actually state that there's a disability for Crowley. The LCBO reviews this, and because of a bunch of circumstances, including the doctor's note and the fact that the harasser had been barred from LCBO stores, they deny the transfer, which makes sense under the circumstances. After that transfer is denied, the employee claims that this is discrimination. She brings a complaint to the LCBO, the Human Rights Tribunal against the LCBO, and she provides a bunch of medical showing she does indeed have a disability. But here's the critical thing about this case. The tribunal dismissed the application because at the time the LCBO made the decision, there was no indication in front of the LCBO that there was a disability. And so the medical evidence presented by Crowley only showed that she was stressed and upset as self-reported. There was no medical for a disability. and therefore the transfer was appropriately denied at that point in time. Now, once you've decided, okay, there is a disability because you have the medical to support it, then you get into accommodation. And accommodating mental health can be really challenging. Instead of Bob can't lift 10 pounds, as Gemma rightfully noted, you get restrictions like Bob should not be put under undue stress. Well, what does undue stress even mean? And that's generally where you're going to send a follow-up note to clarify medically, what does undue stress mean? But it's always going to be a little bit more ambiguous. It's never quite as easy as Bob can't lift 10 pounds. It's also the fact that mental health is generally impacted both by work and non-work related factors. So you might have accommodated Bob, you've got in a good groove, things are going well, and then something outside the workplace changes Bob's mental health, and you have to re-go through the accommodation process again. It can be dynamic. Symptoms can be unpredictable. There's also large privacy constraints. Gemma had mentioned these already, but because of the increased stigma around mental health conditions, you have to be particularly careful when you're accommodating to keep privacy in mind. So how do we go about doing this? The watchwords are flexibility and creativity. You don't want to be constrained by what you think is an appropriate accommodation. You want to think broadly about what can you do. So what we've done here is we've given 5 examples of categories you might want to think about. This isn't the end-all be-all of accommodation. It's going to have to be flexible and creative, as I said, but these are the types of things you want to be thinking about when you're talking about a mental health accommodation. So first, can you modify the job duties? If there's a bundling of tasks for a certain worker, can you unbundle some of those? Can you redistribute some of the tasks? Can you job share? And that does not mean that 2 employees working half-time on the job together are both being paid full-time. Okay, it might be that you're broken into part-time positions. It might be that, they've got help for some of it, but not all of it. It doesn't necessarily mean 2 people being paid completely the same salary for one job. Can you modify the work environment? We're seeing a lot of cases these days about things like the employees got restrictions because of their ADHD. And so we're talking about, can we reduce distractions in the work environment? Can we make sure there's somewhere that's quieter or less disturbed or more out of the way? These are all things we can think about. Can we adjust scheduling? So often when you have a mental health accommodation, you'll get notes about, well, Bob may not always be able to come at 9 o'clock. Sometimes he might have to come in at 9:30. Sometimes it might be closer to 10 because he might have difficulties in the morning. Well, at that point in time, remember the doctors provided the restrictions. You get to determine what's the appropriate accommodation based on those restrictions. You might say, Bob, why don't we start you every day at 10? That meets Bob's restrictions, limits the difficulty in your workplace by having Bob sometimes here at 9:15 and sometimes here at 9:30 and sometimes here at 10, and is appropriate under the circumstances. Work from home can be extremely complicated. We can, and I have run entire seminars just on work from home. But remember, the employee is entitled to the accommodation they need, not the accommodation they want. And a doctor who says so-and-so needs to work from home, you are entitled to ask a couple more questions about what is the actual restriction that requires them to work from home. Because work from home may not be something that you can deal with in your workplace. They may also need time off for medical appointments and treatments. You have the right to ask them to make it as minimally disruptive as possible. That being said, if they need to see a specialist at 2 p.m. on a Wednesday, you might have to accommodate that as well. Training. Training is a great idea if you have an employee who has, indicated some trouble with a task, or you think the employee is exhibiting trouble with a task, and you might be approaching it and thinking, well, Bob can't do this task. Before you get there, let's provide Bob some extra training and some coaching. And it can cost money, so think about ways you can do that that are practical for your workplace. Do you have an incoming employee and you can pair Bob up to redo the training with that incoming employee? Do you have recorded training that Bob can do? Can Bob shadow someone for a little bit? Can Bob get some coaching during his one-on-ones? Those are all viable options and will show that you, the employer, are taking all reasonable steps to try to get Bob up to speed before you decide this just isn't working. This task maybe is something Bob can't do right now. Supervision and management's a big one. Because when you get the note that says Bob's extremely stressed, he's got generalized anxiety disorder, his supervisor is causing a lot of that stress, and interacting with his supervisor is making his symptoms worse, is usually what the note says. But that doesn't necessarily mean you need to move them to a different supervisor. Sometimes it does, but it doesn't always. Can you change the method of communication? If it's the unpredictability of meeting with their supervisor that's causing stress, can you schedule a meeting every day for 10 a.m.? Can you have them communicate at the end of the day in a set form what they've done during that day? If they're finding it difficult to be on the phone, can you have them meet in person? These are all the sorts of things you want to think about in terms of putting together an accommodation for an individual. Now, you also want to think about the fact that there is going to be quite possibly relapses, setbacks, and absences, and that can be really difficult on a workplace. Now, there's possibly going to be changes to restrictions or prognosis, and you want to make sure that especially your frontline managers are supported in the fact that there might be conflicts that arise in relation to their disability, especially with coworkers. You get a lot of coworkers who will be like, well, Bob gets to come in at 10. I want to come in at 10. That's unfair. And you want to give your frontline managers the tools to really deal with that, which would include giving them the script of how do they communicate this to colleagues, saying, well, Bob has spoken to management and we've come to an agreement. If you have a need to come in at 10, please don't hesitate to let me know why, and taking it from there. Absenteeism, as I mentioned, is generally a big issue when you're having a mental health accommodation because of that fact that somebody's mental health status might change and very unpredictably. If somebody's going to be experiencing manic episodes or depressive episodes, they do not, unfortunately, come on a schedule. And so what you want to think about is an absence management program. And you can include individuals who have mental health disabilities in an AMP. And what you want to do is you want to set it out for, and I'm going to get back to what a non-culpable absence is, but just bear with me here. If there are absences caused by the disability, you might be able to track them, so long as that you are compliant with human rights legislation, which generally means tracking them separately from absences that are their fault. And then you might have check-in meetings. So if you're having a certain level of absenteeism, or if the absenteeism increases, there's going to be a check-in meeting. You'll discuss with them what's going on. You'll ask them if there's any changes. You'll ask them how long it's going to be anticipated that they're adopting to new medication, if that's the cause of the absenteeism, that sort of thing. You might also have a clear warning of possible outcomes for failure to meet AMP standards. Because remember, just because somebody needs to be absent doesn't mean that they don't need to follow call-in procedures, and it might be accommodated call-in procedures, but they need to follow those procedures, or maybe it gets to the point where their absence is so frequent that the job just can't be done, and then we're talking maybe about a leave of absence. We've mentioned last chance agreements there, and I'm going to leave that to Ethan to talk about because that comes up more often in substance use disorders. So I'd mentioned I come back to culpable, non-culpable. Let's talk about discipline and termination for the individual with a mental health accommodation. Because I get the call all the time saying, Allison, I've got this employee, Bob, has a mental health accommodation. Can I even discipline Bob? The answer is yes, but it's a yes, but. You can discipline if the conduct is what we call culpable, which means it's Bob's fault. Generally, if the conduct is non-culpable, so it's not within the employee's ability to control or change, so it might be caused by their disability, they need absences because of it, they can't control or change that, then you might be looking at accommodation. The employee has the onus to show that their conduct is caused by their medical condition. The other thing you want to remember here is that if you're going to be disciplining Bob because he's not meeting a certain performance standard, you do have to show that that performance standard is a bona fide occupational requirement, as Gemma mentioned earlier. So let's look at this case, which is Lane and AGDA which is a great case about how termination discipline cannot be based in stereotypes. So what happened is Lane applies to AGDA to work. He is told that it's a high-paced environment, tight turnarounds on timelines. He says he can do that. He's hired. Right after he's hired, he discloses that he has bipolar condition, and then he starts exhibiting symptoms. AGDA terminates his employment and says he lied about the bipolar condition during the hiring process. And it was based on the assumption and perception that Lane could not do his job. And so, unfortunately for AGDA, the Human Rights Tribunal says that's not appropriate. You rushed in to terminate without properly investigating. And the divisional court agreed. Because AGDA did not fulfill that procedural duty to really investigate what were Lane's actual restrictions, and they didn't conduct the appropriate assessment, they could not terminate his employment because it wasn't clear they couldn't accommodate him to the point of undue hardship. Herbert and Parole Board of Canada is a case that shows the steps needed to terminate the employment of an employee with a disability. And they are a fair number and fairly complicated. Herbert had a history of work quality issues. There'd been a couple of years of bad performance. He's transferred to another position at the same pay to see if he does a little better there. After that transfer, Herbert discloses that he has chronic major depressive disorder and he goes off on sick leave. He comes back to work after a work hardening process, and the parole board says, look, we've got a special project. Why don't you try this? Special project works really well. Things are going great. The problem is that the special project can't be continued indefinitely. So the parole board says, Herbert, can you undergo a neuropsychological assessment because they didn't have adequate medical at the time? And Herbert says, nope, won't do that, refuses. Because the special project then ends, the parole board terminates Herbert's employment. Herbert grieves everything. I think that's an easy way to say it. He grieves absolutely everything that you just heard about. So what happens with those grievances? Well, the grievance about the transfer was dismissed because the labor board says that wasn't disciplinary when we moved you to another position. The parole board moved you to another position. There we go. It wasn't a demotion. You got paid the same. That's fine. The grievance about the parole board failing to accommodate Herbert was also dismissed because of that lack of medical. The medical said things like Herbert should continue with only the job duties he's familiar with, but also said Herbert cannot do those duties. So the parole board had tried their best, had sent out medical clarification notes, wasn't getting anything, so they didn't fail to accommodate. But the termination grievance was upheld. And that was because the employer just kind of shrugged and gave up after asking for the IME, and they turned around and terminated his employment. They knew the medical information was insufficient. They should have made that clear to Herbert, and they should have pushed a little bit more before terminating his employment. And so as you can see, quite a few steps. You do have to make sure your T's are crossed and your I's are dotted if you're going to terminate the employment of somebody with a mental health condition. Now, where should maybe this have all landed? In frustration of contract. So what happens is that if you have an employee where they have non-disciplinary, non-culpable reasons, but it's just not working out, frustration of contract is where you might end up. Frustration of contract means that the contract as imagined between the parties just can't be performed anymore due to circumstances outside the control of either party. The classic case of frustration of contract when we get to mental health is because of absenteeism. So generally, you've gone through that bullseye approach that Gemma took you through. You've tried to accommodate. The only accommodation that's working is the employee goes on a leave of absence. And then it's been a year and the employee's not back at work yet. And the medical you are now getting indicates that there's no reasonable prospect that the employee will be able to return to the work in the foreseeable future. If you have that medical, then the contract may be frustrated, which again is sort of that no fault, contract's frustrated, end of employment. It's easier to establish the longer the employee is out of the workplace, but there's no magic number. It's not like they hit the 2-year mark of being out of the workplace and suddenly it's frustrated. You do need that sort of clear medical suggesting that there's no reasonable prospect they can return to work in the foreseeable future. Now, if your employee is on disability benefits, which would normally be the case in this situation, you might know that generally LTD starts off, so LTD being long-term disability benefits, starts off by the employee qualifies if they can't do their own occupation. It's called the own OC threshold. So if they can't do their own occupation, they get LTD benefits. But about a year out, a lot of insurance plans will then say, well, the employee will only continue to get long-term disability benefits if they can't do any occupation. And that's a good time to be thinking about, is there frustration of contract? Because your insurance benefit provider has now thought, well, the employee can't do any occupation. You can't rely just on the insurer having made that determination. You still need medical on your own. But it might be a good time to inquire about the employee and their status and how they're doing, send out a letter to their doctor, get some information back about the prognosis, because maybe it's now at the stage where there's no reasonable chance of them coming back to the work in the foreseeable future. Why is this really important? It's important because if there's frustration of contract, you don't have any obligation to provide common law reasonable notice or pay in lieu thereof, which is a huge liability normally. Instead, you may have the obligation to provide statutory termination entitlements. So there'll be statutory notice and statutory severance, if applicable, which is mostly in Ontario. So this depends on your jurisdiction. If you are in Ontario, if you are a federally regulated employer, if you're in Quebec, or if you're in Saskatchewan, you will probably have to pay statutory termination entitlements upon frustration of contract. So not common law, but yes, statutory minimums. If you are in British Columbia, Alberta, Manitoba, Nova Scotia, or PEI, you may not even be required to pay the statutory minimums upon frustration of contract. Again, double check with your lawyer before you go ahead and do it, but you may not have to pay anything. And so it's important when we're talking about this type of thing, if you have an employee who's been especially on leave of absence due to their mental health condition, to be thinking about frustration of contract, because it is where numerous cases, including the Herbert case, should have ended up. And with that, I'll turn it back over to my colleague Ethan to talk about substance use disorder.
Thank you, Allison. Good morning, everyone. And thank you to my colleagues Gemma and Allison for talking about that great information. We learned about the accommodation framework in general. We learned about how we can accommodate and deal with mental health conditions. And this morning, I'm going to be talking about a similar and equally as important topic, which is how we deal with an employee who may be dealing with a substance use disorder, and if they are, how we can accommodate that. The first thing that we ultimately, as employers, want to do if we suspect that an employee may be dealing with a substance use disorder, or ultimately if they're just using substances while at work, is we need to determine if this actually amounts to an addiction or if it is just, what I may term as the casual use of drugs or alcohol, or the use of drugs or alcohol for fun, but not necessarily amounting to an addiction. And this is a really critical distinction to make. And that's because an addiction to drugs or alcohol, which we refer to as a substance use disorder, is a disability under the Human Rights Code. And as such, it receives all the protections anyone with a disability is entitled to under the Human Rights Code. By contrast, the casual use of drugs or alcohol, the use of drugs or alcohol for fun, is not necessarily a disability if it's not an addiction, and it may not be entitled to the same protections. When we're dealing with possible substance use disorders, as my colleague Gemma explained, as my colleague Allison explained, as it relates to mental health conditions, an employer does have a duty to inquire. as to whether or not there may be something that is protected under the code. Vice versa, an employee has a duty to disclose whether or not they're suffering from a substance use disorder. And ultimately, it's the employee that has the onus of establishing and generally establishing with sufficient medical evidence that they have a disability related to this substance use, that it is an addiction or a disability that is protected under the Human Rights Code, and it's not just the casual use of drugs or alcohol. This is a decision called Sunnyside Homes. It's from 2019, and it's a labor arbitration decision. It takes place in a unionized environment, but the same principles generally apply to employers, unionized or not. And this decision really highlights the importance of the duty to inquire, and ultimately the consequences an employer could face if they don't take reasonable steps to satisfy that duty to inquire. Because of the stigma that surrounds substance use disorder and ultimately the stigma of the disorder itself, the duty to inquire, an employer's duty to inquire, is particularly important, as an employee is, in reality, a lot less likely to come forward and proactively disclose that they're dealing with a substance use disorder. So that's what we see in this decision. We're dealing with a griever who was a nurse in a long-term care home, and she was dismissed from her employment after it was found out that she was stealing narcotics for approximately 2 years. And this wasn't a situation where the union and the employer disagreed about the consequences of such conduct. In fact, the union and the employer agreed that this conduct constituted the highest level of misconduct, and it was ultimately just cause for termination. Now, the griever did not disclose that they were dealing with an addiction until after this misconduct was brought to the attention of the employer. However, that doesn't mean that the employer did not have a reasonable opportunity to understand what this employee was dealing with. And in particular, with this decision, the employer had received reports that the griever had a troubling appearance, they were demonstrating troubling behavior, and ultimately, it should have led the employer possibly to take reasonable steps to inquire as to what was going on with this individual. And when I say troubling behavior and troubling appearance, it's really kind of the stereotypical, quintessential types of examples we're dealing with when we talk about substance use disorder. It was reported that the griever had glassy eyes, they had declining hygiene, and it was being noticed in the workplace. They were showing up to work extremely early. All of these things should have indicated to the employer, we should try to see if, at the very least, is everything okay? Now, the union ultimately grieved the termination, and the employee was reinstated by the labor arbitrator. This was because the arbitrator determined that the employer had failed to meet its procedural duty to inquire. And in this case, it's because the employer simply took no steps to inquire about the employee whatsoever, and the employer failed to establish undue hardship. So this decision is a really great example of an employer that didn't take any reasonable steps to address reports of a possible substance use disorder. And the result was a really significant remedy of ordering that the terminated employee be reinstated to their former position. With that in mind, I think it makes sense now to discuss what are some reasonable steps that an employer can take to investigate concerns about a substance use disorder in the workplace. The duty to inquire, which my colleague Gemma talked about, which my colleague Allison talked about as it relates to mental health conditions, very commonly arises when there is suspected workplace impairment. And when that duty to inquire arises as it relates to substance use disorders, the first step may be having a discussion with the employee to try and determine if the employee's conduct or the reports that you've received about the employee's conduct, if we're thinking back to the Sunnyside Home decision, is or is not related to a possible substance use disorder. If there is a substance use disorder, the employer should probably consider accommodation and whether or not that's possible. And if there is no substance use disorder, it's reasonable in some circumstances to consider discipline. One question that I get all the time in my practice, one question that we see all the time is, what do I do if an employee attends work and I think that they are under the influence of drugs or alcohol? It's a sensitive situation and it's a potentially dangerous situation. If we're not in a safety sensitive environment, it can cause reputational harm. If we think of employers who operate call centers, pardon me, call centers, if we think of employers or employees who are account managers who may be dealing with potential clients or accounts while under the influence of drugs or alcohol, that can cause reputational harm. Similarly, it can also cause physical harm. If we think of construction sites, if we think of manufacturing facilities, warehousing facilities, where employees are operating heavy machinery, heavy equipment, an employee under the influence of drugs or alcohol can cause severe, sometimes fatal injuries. So, how do we deal with that? What's the first step? Well, first, you want to document the conduct or the symptoms that you think is leading you to believe that the employee may be under the influence of drugs or alcohol. If you're able to, it's great to have two managers verify these symptoms independently on their own. So it's not just you who's thinking this, but it's another member of management who says, you're right, or who says, I also notice these symptoms, and it leads me to believe that this individual is under the influence or maybe under the influence of drugs or alcohol. You want to conduct a drug or alcohol test if doing so is permissible under a reasonable employer policy. I pause here for a brief moment. This specific point is a huge topic. What constitutes a reasonable employer policy for drug and alcohol testing? When is drug and alcohol testing permissible? This is a massive topic. We could do an entire seminar just on this topic. Ultimately, the big picture is that there has to always be compliance with human rights legislation. We can't contract ourselves out of the law here. And there must be a clear reason for testing. Generally, testing is only permissible in safety sensitive positions, and testing should be as minimally invasive as possible. Now, after those two steps are complete, if we still believe that the employee is under the influence of drugs or alcohol, you want to send them home, not in their own car, but in a taxi cab, and follow up the next day. Sending them home in that taxi cab is crucial. If you believe that the employee may be under the influence of drugs or alcohol, do not put them in a car to drive themselves home and commit a crime. It could lead to liability for the employer. It could lead to the employee or somebody else becoming seriously or fatally injured. And it may also indicate that maybe you didn't truly believe that they were under the influence if you let them drive and if you sent them home to drive themselves. So put them in a taxi cab. It's critical, mostly for the health and safety of that employee and for everyone else. The next day, you want to speak to the employee about the conduct that you observed. And if you had another member of management observed conduct, also about the conduct that that member of management observed. If you conducted drug or alcohol testing, you can also tell them the results of that drug and alcohol testing if it's available to you. Now, it's critical after you've presented this information to the employee to give them an opportunity to respond here. There may be a reasonable explanation outside of drugs or alcohol to explain why they were acting the way they were or why they were exhibiting the symptoms that you or another member of management noticed. And it's a critical part of the employer's duty to inquire to give the employee that opportunity to speak. And lastly, you also want to inquire if this conduct may be related to a substance use disorder. If the employee says the conduct is not related to a substance use disorder, then you can treat it as culpable. But what do we do if the employee says the conduct may be related to a substance use disorder? Well, first and foremost, we don't have to take their word point blank, like my colleague Gemma and Allison explained. We are entitled to ask for documentation confirming this disability. And so first and foremost, as employers, we can request medical documentation to ultimately confirm that this employee is suffering from a disability, that this substance use that the employee is going through amounts to an addiction is protected under the Human Rights Code. We can also ask if they're going through a treatment plan. Now, that doesn't necessarily mean we are entitled to the entire treatment plan, but it does mean that we're entitled to some information about it as it relates to their workplace restrictions. You want to focus on accommodation and accommodating the treatment of the employee, ultimately to allow them to return to work free from impairment. The type of accommodation that you offer to an employee may depend on the physician's assessment, the medical evidence that you are in receipt of, and whether the work is safety sensitive, right? We're going to have different accommodation techniques depending on if we're working in a construction site where we have open work, heavy equipment going on, and warehousing where they may be using cherry pickers, going through tight alleyways, possibly running into employees while using heavy machinery, versus, to use my previous example, a call center where there may not be as safety sensitive environments. This decision, Vancouver Shipyards and Marine Shipbuilders, illustrates that when an employer is investigating potential impairment, the employer must tailor that investigation to be appropriate in the circumstances, right? The investigation into potential impairment is contextual, it's fact specific. So in this case, in this decision, the griever worked in a safety sensitive position. They were a spotter, and there was a workplace accident in which they were partially responsible or in which they should have helped avoid. The employer required the griever to take a drug and alcohol test, and this was pursuant to their drug and alcohol policy at the time. The results of that test was that the griever's urine had tested positive for cannabis metabolite. And after that, the griever admitted to the employer that he had smoked cannabis the night before his shift. So not immediately before his shift, not the morning of, not the day of, the night before. And the employer's drug and alcohol policy, importantly, did not prohibit the off-hours use of cannabis. So what did the employer do? The employer ultimately required the griever to participate in an independent medical examination, and in addition to that independent medical examination, a 12-month drug and alcohol monitoring program. And the independent medical examination results came back, and it reported that the griever did not have a substance use disorder. The griever stopped smoking cannabis, the griever returned to work, and ultimately the griever successfully completed that 12-month monitoring program. But that doesn't mean that the union in this situation agreed to the testing, agreed to the medical examination, agreed to that monitoring program, because the union ultimately ended up grieving all three of those things. And there's some pretty interesting results about what the arbitrator found in relation to each of these. So as it related to that initial drug and alcohol testing, that urine test that showed the griever was positive for cannabis metabolite, the arbitrator found that that initial test was justified. Impairment was a reasonable line of inquiry, and it was ultimately reasonable for the employer to have that employee undergo the drug and alcohol test. The independent medical examination, however, was not justified. Just because there was a positive urine test, that didn't establish that the employee was impaired at that time or that they were unfit for duty. And ultimately, requiring an independent medical examination in that situation as a condition for the employee remaining employed was not reasonable. Similarly, that 12-month monitoring policy that I spoke about was also found to be unjustified. The employer's own drug and alcohol policy in this situation did not prohibit cannabis use prior to work, and the griever did not have a substance use disorder. And so with this context in mind, the arbitrator again found that requiring as a condition of remaining employed that the employee undergo a 12-month monitoring program was simply not reasonable in these circumstances. And as a result, the griever was entitled to damages for violation of privacy in the amount of $15,000, which is not a small amount of money. It's quite significant. In this case, as I mentioned, the arbitrator found that an independent medical examination was inappropriate, and for the reasons we discussed. However, an independent medical examination may be appropriate when less intrusive means are exhausted, and there is a legitimate need for an independent medical examination. And we specifically see this a lot when we're dealing with safety-sensitive environments or job performance risks. For example, had the employee claimed that he had an addiction right? In this situation, he did not have a substance use disorder, but had the griever, the employee, claimed that he did have an addiction. Given that he worked in a safety sensitive environment, the independent medical examination may have been found reasonable by the arbitrator in that new set of facts. So, what are some strategies when we are dealing with specific ways to accommodate a substance use disorder? Well, accommodating a substance use disorder can be challenging because relapse is recognized as a symptom of addiction. You'll recall my colleague Allison talked about the potential for relapse when we're trying to accommodate a mental health condition. Well, that reality is present when we're dealing with substance use disorders as well. The potential for relapse should always be considered by an employer during the accommodation process if you are accommodating a possible substance use disorder. And ultimately, an employer's accommodation efforts, if it is reasonable, may require multiple attempts to return the employee to work before undue hardship is established. It's generally not permissible to say, this employee relapsed, sorry, you're gone. Now, of course, it's contextual. The employer has to do what's reasonable in the circumstances, but plan for relapse. Understand that it is a part of the recovery when dealing with substance use disorder, or at least it can be. And ultimately, if you've done all reasonable steps to try and accommodate an employee, you don't really think there's anything else you can do, one final tool that can often be used is a last chance agreement. And this is really a last resort. Now, a last chance agreement, as the name suggests, is used if accommodation is unsuccessful and if an employer wants to give an employee that one final opportunity to remain employed. You don't want to terminate their employment immediately, so a last chance agreement is a great way to go. And what a last chance agreement does is it will set out the specific conditions on which the employee's employment will continue. What do these conditions include? As you see on the screen, it may include that the employee abstain from drug and alcohol use. Pardon me. Now, that may not be a blanket ban on all drug and alcohol use, right? We have to consider the physician's assessment and whether or not they're recommending something like that. But it can say they abstain from drug and alcohol use. It can say that they participate in treatment, that they undergo drug and alcohol testing. It's highly contextual, and the conditions will often depend on the specific circumstances that you're dealing with in that moment. It's also important to remember when dealing with last chance agreements that the parties cannot contract out of human rights legislation or their human rights obligations, both of which. And ultimately, in a last chance agreement, the parties will agree that any breach of that agreement will constitute just cause for dismissal and undue hardship for the employer. These can be a really effective tool to demonstrate that the employer has fulfilled its duty to accommodate, that the employer has really tried to take every reasonable step in the circumstance to accommodate the employee. We've given them now a last chance agreement, and if it's unsuccessful, it's pretty good evidence, as long as we've done everything reasonably, to demonstrate that we've satisfied our duty to accommodate or work towards satisfying that duty to accommodate. Now, this decision, Toronto District School Board and CUPE, fairly recent, from 2018, it's a useful decision for employers because in this decision, what we see is that there was a last chance agreement and the arbitrator was reluctant to second guess that last chance agreement. So in this situation, the griever's employment was terminated for violating the last chance agreement. And they violated two of the terms. They failed to provide proof that they had completed drug treatment, and they failed to provide they failed to submit to a drug test, both of which were conditions of the last chance agreement in this situation. Now, the union alleged that the employer had breached its duty to accommodate, and at arbitration, they submitted post-discharge evidence that the griever was in fact engaging in a treatment plan, despite the griever not providing proof of that initially. Ultimately, what we see is that the grievance was dismissed. The arbitrator in this situation was reluctant to second guess a last chance agreement without compelling evidence of post-discharge rehabilitative potential. My colleague spoke earlier about disciplining if we can't accommodate or if it is culpable behavior. And so how do we discipline? This decision is really great for explaining that. It's called Cambridge Memorial Hospital, also fairly recent from 2017. And ultimately, even if the employee has a substance use disorder, what we see from this decision is that not all misconduct is non-culpable. So even if they do have a disorder, even if it is an addiction, not everything that employee does is necessarily non-culpable. The employee can still be disciplined and held accountable for culpable conduct. So some key facts to understand about this decision. We had a nurse who admitted that they had been stealing Percocets since 2011. She diverted drugs away from patients who were prescribed that medication, gave them fewer pills than they were prescribed, and stole the rest. The hospital's investigation in this situation revealed that the nurse's theft of Percocets dated back to 2006, and her theft of Tylenol 3s dated back to 2003. This was a really extensive and long-lasting scheme. The nurse denied or claimed that she had no memory of the earlier thefts. And further, the nurse actually admitted to the employer that she could go on vacation without using substances and that she did take vacations without needing to have or travel with, her quote unquote stash. She admitted in this situation, so the employee admitted that she knew all along that what she was doing was wrong, but she feared coming forward both because she was embarrassed and ashamed and because of potential legal consequences, including being fired or criminally charged. So the employer dismissed her for cause. And ultimately, at arbitration, what we see is that there was no evidence that the nurse's substance use disorder, right? She did have a substance use disorder here, but there was no evidence that that specific substance use disorder was sufficient to cause her to commit these thefts and to falsify patient records. It wasn't the substance use disorder that led her to do this or that diminished her capacity to act properly. And as such, that behavior was culpable. And so post dismissal, even though the nurse in this situation demonstrated that she had a commitment to rehabilitation and that she was unlikely to relapse, the dismissal was upheld. And that's key here. That's a critical difference from the Sunnyside Homes case. The addiction did not cause misconduct, right? It was culpable behavior. The substance use disorder did not lead the nurse to act in the way that she did. What the arbitrator finds is that the nurse made a conscious decision here, and she should be held accountable. Now, with that, that concludes my discussion about substance use disorder. We're now going to go straight into question and answer period. And with that, I pass it over first to my colleague, Allison.
Thanks, Ethan. So we have lots of extremely good questions. Let me start off with a couple of them that we've seen a couple of times. So the first one I've seen a fair number of variations on is, does a note indicating solely that like the employee must work remotely due to anxiety or mental health, is that sufficient? Or should we be asking for a more formal functional abilities form? So the answer to that is something you should definitely be asking for more medical. So let's say you get that note and says employee Bob has to work remotely due to anxiety and mental health. I would be strongly encouraging you to ask more questions and to make them more pointed questions. So that might be a medical note in return saying, dear Doctor of Bob, we've received your note on this date. We have further questions that we need in order to properly accommodate Bob. And you might be asking things like, is there a diagnosed disability? And you're not asking for what is the disability, because you're not entitled to that, but just whether there is one. You might also ask things about like, what are the exact restrictions? And you provide the job posting as you actually heard from Gemma, I think earlier. These are the types of questions you'd want to ask. You'd also want to ask things about, what's the anticipated return to work? Full time in the office look like? That's the type of question you can ask and you should be asking under those situations. The just must work remotely because of anxiety is not sufficient, although you might provide an interim accommodation while you try to have them get more medical. Talking about interim accommodations, I received a question that was asking about working in certain environments and accommodating where it's very challenging. Can the employer accommodate for a set period of time before it becomes undue hardship because that accommodation needs to be indefinite or long term? That's a great question. And yes, what you would want to do is you'd want to make it very clear that this is an interim accommodation. And this might be granted where the employee is being reassessed, or you're waiting for more medical, or let's say they're in a period of transition, or the employee's doctor has said, they're going through a particular type of episode, they're going to need 2 weeks, then I anticipate stabilization. You would say to the employee, we can do an interim accommodation for this period. Now, you would, as I said several times now, need to be very clear that it is interim. We can accommodate this on an interim basis, and this is what it will look like, but we won't be able to accommodate past this period of time. And then you will need to have very clear notes and records for yourself about why you can't do this accommodation for long term. But certainly, there are many occasions where an interim accommodation might be possible, but long term, it would become undue hardship. This is particularly true if you're working for a small company. We also received a couple of questions about paying for medical notes. And so I want to make sure we address that as well. One of them said, what financial responsibility does the employer take on for medical assessments and documents if they're required for accommodation? Is the employer expected to reimburse the employee? And if not, could that be why the employee does not comply with the request? So on and so forth. So you're not necessarily required by law to pay for that sort of clarification medical note that you're asking for, but it's often a good idea. So if the employee's provided a note and it just says need to be off work or need to work from home because sick, ill, anxious, whatever the case may be, and you are writing back to the doctor saying, this is the information we need, you might want to provide a contribution towards the cost of that medical note. The practical reason is just that you're likely to get a better response. If the doctor knows that they're going to get paid for it and the employee knows it's going to get paid, you might get a much better response than you would otherwise. Sometimes, yes, you might also get into the situation where you follow up with employee Bob 2 weeks later and say, Bob, you said you'd get us a medical note. We haven't received anything. And Bob says, well, the doctor says I have to pay for it and can't afford that. It happens. It's not that common. But certainly if that's the case, then sometimes you're just avoiding a whole bunch of problems by offering compensation. And it might just be contribution towards a medical note. If you are requiring an IME, and I don't think this is where this was going, but yes, you would be paying for the IME. Let's do one more question before I turn it over to one of my colleagues. So the question I've got here is that how do you deal with mental health issues and neurodivergence being brought up as a defense to workplace misconduct, i.e. in a workplace investigation context? Big question. And I know we're focusing on accommodation today, but to give you an initial sort of response to that, you'd want to ask them to provide medical to substantiate their restrictions and their disability. So employee Bob says, well, I was doing this thing because, couldn't help myself. It's because of my mental health conditions, because of my neurodivergence. Make sure you ask Bob for medical as part of that investigation. You want to make sure you get some idea of those restrictions. And once you have those, you might be determining whether or not that's justified. You might be talking to Bob again about what this means and what happened. If you're doing especially a harassment investigation, remember if they knew the conduct was unwelcome, they're going to have a very, 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 very solid medical to show that somehow they knew it was unwelcome, but it was justified because of their mental health disability. With that, let me turn it over to Gemma for some questions.
Thanks, Allison. So just looking through the question box, I see a few questions about whether an employer can change the employee's rate of pay, specifically through the bullseye approach. So when offering alternative and or comparable employment. So I just want to note that the first option, if they can't perform the same job as they were in previously, would be a comparable job. And comparable would be in terms of pay, responsibilities, duties, and all of that. So that would be, you do want to try to keep them at a similar rate of pay first, but if that's not possible, and again, it's very contextual, so in some circumstances it wouldn't be possible, it is okay to change the rate of pay. So it shouldn't be the first option, but again, the main goal of accommodation is to have the worker be in the workplace performing meaningful work in a way that's safe. So in most cases, it's going to be better to keep them in the workplace doing that work, even if they aren't making the exact same as they were making previously, as opposed to going on a leave of absence, for example, where they're not in the workplace anymore. Another question we got is about gathering information about the accommodation that the employee is requesting. So again, recalling there's the procedural duty and the substantive duty. I believe this question is about gathering information in the procedural stage and whether this can be done, it should be done solely over email or through written means, or whether it can be done verbally. So to make it clear, it doesn't have to be a robotic process where the employer doesn't want to speak to the employee unless it's about accommodation, unless it's over email. But it is always better to either have it in writing, the communication, or if it's a verbal conversation, to have some kind of contemporaneous notes about the conversation that was had. Again, it doesn't have to be a robotic process. In fact, when it comes to accommodation, these can be quite sensitive issues for the employee. So it could be nice for them to have conversations in person as well, because it is a collaborative process. But we want to make sure we're documenting that we asked about what they need and we're listening and we're considering those creative and flexible strategies that to respond to their request. And this is because there's the procedural and the substantive duty, right? So the employer has to meet both. And in order to show that the procedural duty was met, we want to make sure that we have some kind of record of that. And then with that, I think in the interest of time, I'll just turn it over to my colleague, Ethan.
Thanks, Gemma. We've had several questions about how to fulfill the employer's duty to inquire in the context of a substance use disorder. What does that conversation actually look like? And the answer ultimately depends on what has led to the employer's belief that there may be a substance use disorder here. So if we're dealing with a situation where, pardon me, if there was an incident that occurred, right? If we think to, for example, the Vancouver shipyards case where there was a workplace accident, which led to the suspected belief that there was a substance use disorder, it may be appropriate in that case to ask the employee directly, you appear to be intoxicated. Are you intoxicated? Have you consumed drugs or alcohol recently? Do you have a substance use disorder? Now, if it's a situation where it's a lot less clear, and oftentimes that's more common, is we're not sure what's happening. We suspect something might be going on related to substance use, but we're not positive. We think about appearance, frequent absences, glassy eyes. If we think back to that original decision I spoke about, you may start the conversation by saying something along the lines of, we have noticed XYZ. We've noticed you have glassy eyes. We have noticed you've been coming in super early, for example. Is there anything going on in your life that right now? Is there anything going on right now? Is there anything that we can help you with? We've also had a question about an employee raising a substance use disorder for the first time, kind of as an excuse to avoid termination. At that point, what do we do? As employers, it's probably best if we try and seek medical documentation and potentially an independent medical examination, right? Again, just because an employee is dealing with a substance use disorder does not mean that they can't also be guilty of culpable conduct, right? Like that decision I spoke about at the very end of my section, where we talked about the nurse who, although she had a substance use disorder, her theft of prescribed medication and her falsification of hospital records was not attributable to that substance use disorder. And so even if she had a substance use disorder, her theft of drugs in that situation was still culpable. So we want to seek medical documentation, possibly an independent medical examination, satisfy as far as it's reasonable that duty to inquire, and go from there. In the interest of time, I'm going to turn it over to my colleague, Allison.
Excellent. Thanks, Ethan. So I know we have so many questions. We're going to try to hit a couple more before we round out for the day. So I have an interesting question here about, does the employer still need to accommodate work from home if work from home would not be undue hardship for the employer? Good question, very common question. When you have that question, I want you to take 3 steps back first, though, because the first question is actually, does the employee's restrictions require work from home? If they don't, then we don't even need to worry about whether or not it'd be undue hardship for you, okay? Because maybe the employee doesn't actually need from work from home. If their employee's restrictions are need to be uninterrupted, cannot travel very far, then you're looking at, where is the office? Is the office, can they be in a portion of the office that is quieter? All of these sorts of things. It needs to be a pretty clear restriction in order to lead to a work from home accommodation. Yes, however, if there is restrictions that justify and mandate a work from home and it's not undue hardship, you are going to have to provide that accommodation in order to abide by the human rights legislation. But please make sure you're doing that initial inquiry first of, is a work from home accommodation actually necessary before you get to, can you do the work from home accommodation or is it undue hardship? We have a question about, actually, we've got about 3 questions on this topic, which is, what do you do in the event the employee has a mental health condition, but they don't seem to be engaging in any sort of treatment for that? That's a really good question. So the first question I would usually ask is, how do we know they're not engaging in treatment? Sometimes it's been raised by the doctor in the note you get back, and sometimes it's just we haven't heard anything, both of which are perfectly fair. If it's the latter, we do maybe want to ask the doctor about, is there a course of treatment? Again, not necessarily the details of it. When will they be reassessed? That sort of thing to hint to the doctor, we would like some information about whether or not they're following treatment. Now, there are some occasions where the doctor might have pointed out very pointedly that there's been recommended treatment and the employee is not following it. At that point in time, I do think you'd have to engage in a fairly complex and nuanced consideration of, can you point to that as being unreasonable under the circumstances and part of the employee's accommodation responsibilities? You generally can't force people to undergo medical treatment, so that would be a case-by-case situation at that point. Another question we've got. What do you do with an employee who's on a leave of absence, says they're never going to be able to return to any type of work, but they're not resigning? So that's where frustration of contract comes back in. So you've got this employee, they're saying, cannot work, can't come in, but they're just content hanging out there. That's the point where if they've been on a leave of absence for a particular period of time, this is what they're telling you, you're probably going to be saying, Bob, we've been having this conversation. You've indicated that you're probably going to be unable to return to work. Completely fair. Can we get you to provide this note to your doctor, get some responses, and then dealing with frustration of contract from that point? I know we're running short on time. So the other common question I wanted to address is, what kind of restrictions would you expect a doctor to provide for a mental health condition? Really good, very complicated question, but a lot of the ones we see are things like, employee is going to need to take regular breaks. They're going to need to be in a quiet location. They're easily distracted. They have a hard time focusing. Their mental health may go through periods where they're experiencing manic or depressive episodes. and during that period of time may need to have a leave of absence from the workplace. They may have difficulties waking up in the morning. Employees easily frustrated. Employee needs tasks in written format. Employee gets stressed by unexpected happenings. Those are all restrictions. So a lot of you, based on the comments and the questions, I'm sure, are getting accommodations from the doctor. Employee needs to work from home. Employee should only work from 10 a.m. to 2 p.m. That's accommodations. The restrictions examples are the ones I just gave you. So if you received a doctor's note that only had accommodations, employee needs to work from home, then again, you'd be going back to the doctor and saying, can you please provide us the exact restrictions for the employee, the medical restrictions from the employee? What are the restrictions we're talking about that have led you to suggest the employee work from home? And you take those restrictions then, and then you're going to formulate accommodations. And remember, accommodations is a two-way street. So you're going to sit down with that employee. You're going to say, we reviewed these restrictions. This is what we think the appropriate accommodation is. And the employee might say, oh, can we do this? Can we do that? You consider it, you work with them, and then you propose an accommodation and hopefully go from there. I'm going to deal with one more question with apologies to everyone because I know there's a lot of questions. For a mental health accommodation, can the accommodation be permanent? For a scheduling accommodation, for example, can the employer push for work hardening? You're going to hate the answer, but it's going to depend on the circumstances and the restrictions. So some accommodations might very well be permanent. So maybe the employee is in a very stable state with their mental health condition, but they're always going to have certain restrictions. And that might very well be that they need certain times off, that they are easily distracted, that they need to be able to take breaks, that sort of thing. Might be a permanent accommodation. Again, it's important for you to be asking those questions of the doctor about what is the prognosis? Do we anticipate a change to circumstances? When are they going to be reassessed so that you can plan for these things? And as we've talked about earlier, maybe you're making an interim accommodation while you get more information. Maybe it's going to be a permanent accommodation. Maybe you're doing an accommodation for 6 months because the doctor anticipates improvement in their condition. You can also inquire of the doctor, work hardening and how is that going to work? Would we be able to, you've said the employee needs to be working half days. When do you anticipate the employee will be able to move to 3/4 days and then back to full time? And those are all appropriate questions that you can ask under the circumstances. So with that, I have to say to everyone, this does bring us to the end of today's program. We hope you find it informative. To answer the single most asked question that I did not get to yet, the video and slide deck will be on our website in a day or so. So if you go onto our website, you will find copies of both our video and our slide deck. If we did not get a chance to answer your question, please drop us a line. We know there was well over 100 questions, and unfortunately, we couldn't get to all of them. Our next HR review webinar will take place on Wednesday, December 3rd, 2025. The topic is in the design phase, and we'll send out an invitation in due course. If you're on our mailing list, you'll get that invitation. If you are not yet on our mailing list and want to receive our briefing notes, newsletters, and invitations to seminars and workshops, please subscribe through our website. You'll notice there's a big red bar at the bottom of every page. You want to go there and you can subscribe. Finally, we'd be grateful if you would fill in the feedback form that will pop up on your screen once we close the Zoom webinar. Thanks again for joining us and have a great day.